What gives me most satisfaction as a mediator is resolving a dispute that seemed at the outset to be impossible to resolve and would lead to friction down through the years, particularly in family situations. What I love about it is that you get to meet different people, you get people from all walks of life, you get real characters, and you get an opportunity to help some people who really need help. The principal advantages of mediation over litigation are that it is much speedier, much more cost effective, it's much more flexible, and it is confidential, so there's no danger that commercially sensitive information or family information gets out into the public domain. The client's role is very important in a mediation as opposed to the lawyer's role in court proceedings. You'll generally find that there are pleadings and there are documents that go backwards and forwards between legal advisors that the client has very little input into. Whereas in mediation, the client is there in the room, the client gives their specific instructions, and at every stage of the mediation, the client is consulted and involved, and the client drives the process, so that the decision in the end is the client's decision. A mediator has an advantage over a judge in resolving a dispute in that a mediator can talk personally to the parties, can work out what their issues are, try and see what the bottom line is that would resolve the issues for both parties, does not have to rely on precedent, and people are much more creative and they have a greater flexibility. So the mediator can encourage them to think outside the box and come up with a more creative solution. Yes, I have handled business disputes for this past 40 years. But because I've a master's in business that specialised in finance, then I can understand the financial documents, and I can understand the commercial sensitivity, and also the fact that speed is very important commercially. Businesses cannot afford to have, they need certainty, and they can't afford to have the matter dragged through the courts for 4 or 5 years. They can't afford the time or the resources to deal with that. If they're a particularly big company, shareholders and funders want certainty and don't want to wait for an uncertain outcome. Well, the pros and cons of having a specialist in as a mediator in any particular dispute would be, firstly, the first main advantage would be that the mediator understands what's happening, understands the issues, so can get to the net issues and the crux of the matter much quicker. The disadvantage may be that some people might perceive, because the mediator understands and has an expert knowledge, that might feel that they're trying to drive the decision in a certain direction. But that's not what mediation's about. It's meant to get the parties to focus and come to their own resolution. It's very important that the parties come to their own resolution, because if they do, then they feel some ownership in it. They don't feel that a judge has imposed this solution on them that they're not happy with. Because when a judge imposes a solution, one person's going to be happy and one person's going to be disappointed. This way, they have come to a decision among themselves that they can then feel that they can move forward with.